I'm sorry, so he can pick the Cantic company. I see documentary. Yeah, or we have the speech about legal issues about the domain UA. And I ask Олександр Папуця to join and to show his slides. After that, we will have one more speech and we will end. But first of all, please pay attention to your alerts. Can you hear me? Can you see me? Everything works perfectly. Okay, I'm sorry. Hello. I hope that you are all truly safe and can take care of yourself and your loved ones. Dear participants, I'm glad to greet all of you on this conference, which is dedicated to such a great anniversary of domain.ua, and it still took place in spite of difficult situation. And when we are talking about the legislation on protection of personal data coming to European standards, it goes really difficult, taking into account practical reasons and implementation. Nevertheless, the issue is really relevant, and we are working on that because the acting legislation is out to date and it doesn't cover the whole range of issues and relations that are coming in practice, and they don't ensure the level of protection of personal data. And the draft law on protection of personal data was developed in 2010, and it was based on the European Directive 95/86 of the Parliament and the Council on Protection of Physical Persons when processing personal data, and on free movement of such data till 95, which is now cancelled and substituted with the regulation of the European Parliament with 2016-69 of 2016 on protection of physical persons in relation with processing of personal data, the so-called GDPR, General Regulation. So it is necessary to provide actually integration, taking into account the obligations that Ukraine took on itself and taking into account the corresponding to the European regulations, the obligations that Ukraine took. We have to act according to the agreements with the EU, and currently, according to the new agreements with the EU, it is mentioned that the new deadline is there for making Ukrainian legislation in line with the European standards, that is December 2023. That is, we've got one more year. Acting legislation currently consists of the law of Ukraine on protection of personal data, and also we have the typical way of processing personal data. And the draft law has to bring the legislation in the field of personal data protection, first of all, in correspondence with the European legislation, that is harmonization with GDPR and Convention on Protection of Physical Persons in personal data processing, the so-called Convention 108+, substituting the acting legislation. Now we are going to talk about the draft law on personal data protection number 8158 from 25th of October 2022, which is currently considered by our Parliament and Verkhovna Rada. And it is worth mentioning that it's not the first attempt. The previous draft law on personal data protection number 8628 was taken out of consideration and was denied. And also there is a draft law on national commissions on personal data protection and access to public information, that is the law on the controlling body on personal data protection, which was not even considered in the first reading. So what does this draft law contain? What should we wait for and what should we expect? We are looking at the main provisions. First of all, it's update of the terminology of the legislative regulation of personal data protection, and it's bringing in line with the GDPR terminology and 108 plus convention. There is a range of terms that were excluded or they have different definitions, and also we added a lot of new, or we mentioned the link to other normative and legal acts that provide definition what is used in the draft law. In particular, we don't have the notion as a personal database because the draft law is not operating. Actually, just like the acting law, we all remember how with the adoption of that we had issue on registration of such bases and so on. And the following terms were added: profiling and wide processing of personal data and processing of subjects of personal data with high risks for them. Direct marketing and wide-scale processing is absent in GDPR, even though it is used in the text. In the draft law, we are using terminology of the regulation, even those terms that are absent in the text. They are used in the regulation. Main subjects of regulations also have the same name as in regulation. In ownership of personal data, that is controller, there might be registrator, the person who registers personal data, and the operator, corresponding administrator, and the subject of personal data. And there is subterm with no changes according to current legislation. The next main aim of this draft law is bringing in line principles and reasons for processing of personal data in accordance with GDPR requirements and 108 convention. So what we've got is fully corresponding to what we have in GDPR, and if we compare that to existing law, then in the draft law the main principles of personal data processing are mentioned, and the controller has to watch that, and this is transparency and minimization of personal data and precise personal data, limited preservation, confidentiality, and reporting. And the reasons are almost the same, but the personal data differs from the draft law. And the agreement of the subject of personal data has to be just for determination of the goal and not those who are performing and strengthening of the rights of the subject of personal data. And in addition to the subject of personal data, also the interests of other physical persons are taken into account, and also the necessity of not only like legal obligations and other things. And the third thing that has to be taken into account, this is the strengthening of the rights of the subject of personal data on processing of their personal data. That is the right to be forgotten, the right to having some secret information against processing of personal data, the right to limit the processing of personal data, right for mobility of personal data, right for protection from automated adoption of decisions, and right for protection of their personal rights. The draft law details and makes it precise rights and obligations of the controller and operator of personal data on processing of personal data on the territory of Ukraine and transmission to other states or international organization. It is describing rights, obligations, and responsibilities of the controller and operator of the personal data. In addition to that, it divides, like controllers and operators are having correct organizational measures in order to protect the personal data in accordance with this law, and how to be capable to prove this. These measures should be updated according to technical needs on their level of development, and also representatives of those who are assigned, they have to cooperate with the controlling body on the issues of performing their duties. Each controller has to perform registration of operation with the systematic processing of personal data. And the controller is responsible for those, and registration of operations is done by protocol by minutes. And each operator has to also conduct registration of operation and processing, which is done also from the name of the controller by writing the minutes or protocol. And the personal data protection is strengthened, and there is personal responsibility for protection of personal data, and also we should conduct monitoring on sticking to the law, and also the worker will be the contact person in cooperation with the controlling body. Currently, we cannot say that registrators will fall under the obligation to have such a responsible person, as far as the draft law determines the conditions where they will be defined. So the main thing is that obligations of controller or operator are related to the processing of personal data, and we have still to work some more on that. And we clearly determine the procedure of the outflow of personal data informed by controllers. That is, they provision for the system that will react to outflow of personal data. Within 72 hours, there will be information about outflow of personal data. And the controller with this personal data has to conduct consultation with the controlling body as a result of the impact of personal data processing, if they inform us about the risk of the high level that cannot be excluded. We also determined the way and reasons for processing of personal data by employer, even though it does not include this, but Article 8 of GDPR gives the right to regulate that with special national norms, and this draft law introduces new provisions, a whole chapter about the personal data, processing of personal data by employer, and you have to pay attention to things that provisions on personal data processing are implied to employer and employee, including the worker. According to the contract, an employer has to process exclusively the personal data of the subjects that are important for the working relationship, and they have to stick to principles of protection of personal data and their obligations as a controller. Personal data given to employer by employee has to be deleted at the same moment when they make decision on refusal to employ that person, excluding some cases provisioned by law, and the employer has to confirm the data processing that is regulating the issue on processing of personal data of workers and personal data on health conditions of the candidate for the position or the employee. They can be done only in some exclusive cases. The data on the health condition of the employees has to be preserved separately from other personal data that are processed, and only by those people who are responsible for non-sharing the personal information, and which is necessary for performing their working tasks. And the employer has to inform the employee about the information on personal data processing that might be collected with the help of information communication technologies, including video observation and maybe video recordings at working place. It is regulated the way of processing of personal data after the death of the subject of personal data. We also don't have that in the regulation and the countries members, they can introduce their own regulations, and this draft law offers the following. The agreement of the personal data subject is in force after 10 years after the death of such subject, if not considered otherwise. If the death was until 18 years, then for 20 years after their death, it's valid. If the subject of personal data did not make other decision before death, and processing of personal data is allowed based on the law. And it is also regulated the way of using and observing the subjects of digital data, and also observing such objects with the help of mobile or other applications, websites, other technologies of digital communications and services, as well as with the help of devices that belong to or are used by representatives of personal data, and only in certain given cases. At the same time, the controllers and operators have to ensure automatized access of the subjects to personal data to all information about them which was collected or created in the process of such processing, and of course automatized possibility of introduction of any changes to their personal data that are processed, including their removal. It is forbidden to deny to the subject of personal data the access to the website or similar or some parts of that, or limit use of programs of software or some mobile application or other digital communication technology or service based on their refusal in giving agreement to personal data processing. And one of the most interesting things, sanctions. Interference with the regulation and the draft law and acting legislation. In comparison with that, there are some certain levels of violations and the sanctions that might be imposed on operator, and those that did not lead to the violation of the subject of personal data leads to the fine for physical persons from 10 to 30,000 hryvnias, for legal persons from 0.05% to 0.1% of the general annual turnover, but not less than 30,000 hryvnias for each separate violation of the requirements of the law. Draft law also establishes the term in 3 years from the day of such violation, which is stopped during the investigation of the case, and the other violation of the law where there was violation of the subjects of personal data leads to fine for physical persons from 30 to 100 hryvnias, and for legal persons from 0.5 to 1% of general annual turnover, but not less than 100,000 hryvnias for each separate violation of the requirements of law. For stricter violations, in particular processing of sensitive personal data or provision of such data to other countries, the fine to physical persons from 100 to 300,000 hryvnias, for legal persons from 3 to 5% of general annual turnover, but not less than 300,000 hryvnias for each separate violation. And additional violations are not mentioned in Article 59 of the draft law. It leads to increase of the fine for 30%, and each next violation within the requirements of the law, which is done in a year, leads to increase of the fine up to 30% from the one that they had earlier. If we compare the amount of fines, then with the turnover, the draft law offers higher fines, but in the amount less than GDPR. What is offered in terms of the new controlling body? So nowadays, there is still work on the draft law on controlling body in the field of personal data protection. This is the law on the national commissions and personal data protection and access to public information, because correspondingly to the draft law, the rights of the controlling body has to be defined by the other law. It determines the status, obligations, and the way of working of the National Commission on access to public information, and it contains really wide rights of the Commission, and there are some issues, some questions about that, and we will pay your attention to that. The corresponding Article 36 on protection of personal data, the controller and operator, as well as their representative, in case if such is assigned to ensure their access to premises and rooms and automatized systems, materials and documents, including based on the legislative acts on protection information with limited access. So the draft law on the controlling body is detailing this process, mentioning that checking of the premises might be done even without the decision from the Commission if there is information from the inspector or the local police officer. So that means that inspector can enter the rooms of operator and operator of public information, and when conducting some checks and investigations on violation, the protection of personal rights and access to personal information, if they present the documents that confirm this investigation. At the time of investigations and checks, they can require from legal persons and other physical persons clarifications and other documentation, including with limited access, confidential, working, and secret information. The inspector also has a right, when conducting the check, have the access to registers, to banking data, including those that contain information with limited access, owners, administrators of which are state bodies or local authorities, independently from the form of ownership. And if some points of this are not performed, then they have the right to involve other bodies that will help them to fulfill their obligations. And if the place is housing, then such checks are done based on the decision of the sentence from the court. And at the end, I would like to mention that neither the draft law on personal data protection nor the draft law on National Commission on Protection of Personal Data and Access to Public Information at present moment were not considered even in the first reading. Therefore, there is no possibility to prognose their final look, as also it's impossible to guarantee their adoption. So we consider that the legislation on personal data protection will be updated according to European standards, but if we can assume about the main law that its structure and main information remains and will remain approximately just as is, and with the maximal correspondence to the principles introduced in GDPR, so the draft law, we truly hope that it will be amended. If you have any questions, then please ask and use the contacts mentioned in here. So I can see that there are some questions in the chat. No questions. So I have a question. So these draft law, in your opinion, when can we expect that they will be adopted, and will we need to change the numbers between the registrator and registrator and clients? First of all, thank you very much, Svetlana, for your question. The first thing is the law on protection of personal data, updated law, was introduced a bit less than 1 month ago, but I truly hope, as far as it's going to come in force from the 1st January 2024, then in the nearest time it should be considered, even though it's not the first attempt, but we truly hope that it's the last and qualitative attempt. And as for the draft law on National Commission, then it's even mentioned as a law with a note that it's Euro integration law. And from what I mentioned during my speech, that also there is a deadline, and maybe it will be adopted in the nearest time, because after adoption of these laws, there should also be certain work done with bringing in line of relevant secondary legislation and development of new normative and legislative acts. And indeed, certain changes have to take place, and certain editing of documents and relationship between the subjects in order to bring them in line with the requirements and legislation that were active at the time. Okay, thank you. Some more questions? No questions. So I would like to give the floor to Dmitro Kompanyuk. Our company greets one more time all the participants with the significant age with the domain.ua, and we think that it's really significant because it's just like 2 years as significant use of domains happened all over the world, and our country, thanks to your team, kind of got their own domains, and we sincerely hope that we will meet together for many more anniversaries after our victory. Thank you.